Welcome to our video on constitutional criminal procedure in South Africa. The point here is that since the adoption of the 1993 Constitution, which was the interim constitution, as well as the 1996 Constitution, which is currently in operation, criminal procedure has been grossly and immensely affected by the adoption of the Constitution. The way that criminal justice and the criminal procedure were handled before the adoption of the post-apartheid constitutional dispensation. But the changes that have since taken place are so fundamental, you want to understand more about them. Now, the objectives of this lecture are as follows. By the end of this lecture, you should be able to describe the influences of the Constitution of South African criminal procedure, identify the main constitutional provisions relevant to criminal procedure, explain the scope of Section 35 of the Constitution as well as Section 36. Of course, there are other sections such as Section 12 and Section 21. Then explain the concept of the presumption of innocence in criminal procedure, and describe the evidentiary impact of police action, which contradicts the Constitution. In other words, if police conduct themselves in a manner that violates the Constitution, how is the evidence that they have gathered admitted during the court during the trial of the case? So, looking at the Constitution, one question you want to ask yourself is which sections particularly are relevant and have an impact on criminal procedure. Now, first you have Section 2, which says that the Constitution is the supreme law of the Republic. Law or conduct inconsistent with it is invalid, and the obligations imposed by it must be fulfilled. So, all law and every action, human action or conduct, is measured against the Section 2, or rather against the Constitution as the standard, as confirmed there by Section 2, which says that the Constitution is the supreme law. And then Section 7 says that the Bill of Rights is the cornerstone of democracy in South Africa, which then means that everything that we do, whether it's done by the police, done by the courts, or whoever, it must conform to the Bill of Rights, which is Chapter 2 of the Constitution, as stated there in Section 7. While Section 8 says the Bill of Rights applies, that is, the Bill of Rights rather applies to all law and binds the legislature, the executive, and the judiciary, and all organs of the state. So it is going to be expected that whether it's the police, whether it is the prosecution, whether it's the courts, or whether it's the individuals themselves, that is the accused or the detained persons, everybody must act in conformity with the standards that are set in the Constitution. While Section 12 says that everyone has the freedom and security, so Section 12.1 particularly guarantees the freedom and the security of the person. And Section 35 is about the rights of arrested, detained, and accused persons. We are going to elaborate on that one. And then Section 36 is the limitations clause. And then Section 39 is about the interpretation of the Bill of Rights. So, in other words, the conduct and the action of the police, of the prosecution, even the way the court conducts the criminal trial process, it must conform to the Constitution, taking into account all these, well, among them, let me say, the rights that have been enshrined there according to the Bill of Rights in Chapter 2. That is from Section 9 of the Constitution. So that's very, very important to take note of. Section 12 of the Constitution is about guaranteeing the right to freedom and security of the person. I would like you to understand this section against the backdrop of what used to happen under apartheid. Uh, During the time of the apartheid rule, people who were suspected of committing crimes could just be picked up and be locked up and interrogated, sometimes going for 90 days or even longer without being made to appear in court. And of course, some people disappeared during that time. A lot of people went missing, probably killed and destroyed and, yeah, buried somewhere by the apartheid authority. So the Section 12 therefore comes against that backdrop as a way of ensuring that people are protected. So it says everyone has the right to freedom and security of the person, which includes the right not to be deprived of freedom arbitrarily without justice. So in other words, an arrest in itself is an example of a deprivation of justice and freedom. I mean, it's a deprivation of freedom rather. So the law says that deprivations of freedom must not be done arbitrarily. In other words, if the police have reasonable suspicion, if they have grounds, they on reasonable grounds suspect that somebody has committed an offense, they must follow due process of the law, and instead of just picking somebody up and locking them up and detaining them for as long as they want without giving them freedom. So Section 12 therefore says everyone has the right to freedom and security of the person, which includes the right not to be deprived of freedom arbitrarily without a just cause, not to be detained without a trial. So anybody who is detained must then be tried in court. To be free from all forms of violence from either public or private sources, the right not to be tortured in any way and not to be treated or punished in a cruel, inhuman, or degrading way. Everyone has a right to bodily and psychological integrity. I think we can leave that part, the second part, by itself, but just focus at 12.1. Those 5 items listed there. So these are the main features of this freedom of security, freedom and security of the person, which the police must observe, which the prosecution must observe, which the courts themselves must insist on ensuring that such rights are observed. Then Section 21 is a very interesting one, saying everyone has freedom of movement and residence. So in other words, everyone is free to live anywhere in the republic. So we are talking here about citizens, and we are talking about anybody who is in the country lawfully. We are saying they have a right to freedom of movement. In other words, they should not be restricted. So the moment then you have a police roadblock, it's actually interfering with the movement of the people. That's why the law itself, according to the Police Act and the other, pieces of legislation, they streamline circumstances in which these roadblocks can be mounted. The Criminal Procedure Act particularly is very, very detailed in terms of how arrests are carried out, how restrictions are carried out, so that people's freedom of movement and residence are not just arbitrarily manipulated and tampered with without their blessing, or without their express consent, if one could call that. So we have spoken so far about Section 12, Section 21. Of course, Section 34 says everyone has a right to have their matter which can be resolved by a court of law brought before a court of law for determination. So that's what Section 34 says. But Section 35 is the one that's very interesting for our own purposes, because it carries so many interesting aspects here. It says Section 35 protects various criminal proceedings, procedural rights, which include the rights of persons, the right to remain silent. That's the first right, one of the rights, of course. And then detained and sentenced prisoners have a right to be informed promptly of the reason for being detained. So you find that when somebody is detained, they must be informed promptly. Then arrested persons have a right to a public trial before an ordinary court. They have a right to be present when being tried. They have a right to be presumed innocent and to remain silent and not to testify during proceedings, and the right to adduce and challenge evidence, and the right not to be compelled to give a self-incriminating evidence. So these are rights. You see, a reading of Section 35 actually is an enactment of what they call in America some of these Miranda warnings, like the right to remain silent, the right not to say anything which might be used against you in a court of law. Yeah, those are some of the very, very critical aspects of Section 35. You may take time to have a look at it. It's quite detailed in these aspects. And maybe, as you shall see later on when we discuss the issue of evidence, it says the evidence obtained in violation of the Constitution or of the law is not admissible in court. So there's so much that Section 35 entails, that criminal procedure so much leans on that one. So the issue of presumption of innocence in criminal procedure actually flows from Section 35. It says here, according to our slide here, the presumption of innocence is an integral element of a fair trial as stated in Section 35(3)(h) of the Constitution. And every person has a right to a fair trial, which includes the right to be presumed innocent. So to be presumed innocent means that whoever meets you, even the police who arrest you, if they happen to do so, they assume and presume that you are innocent. So arrest is just a procedure to ensure that the accused is brought to court. And that is confirmed in Section 38 of the Criminal Procedure Act, as well as Section 17 of the Child Justice Act. That arrest is just a way of bringing the accused before court so that they may answer questions. It does not mean that the accused is a criminal. Everyone is presumed to be innocent until proven guilty in a court of law. So there's that presumption of innocence. You are innocent as far as the law is concerned. And then you have a right to remain silent. You should not be pushed and be made to make any confession that might, complicate things for you, and you incriminate yourself in the process. You have a right not to testify during proceedings. So there is no pressure upon the accused to testify during proceedings. And the presumption protects the accused from prejudgment, prejudice, and bias. One is innocent until they are properly convicted by a competent court of law. We have a video where we speak about legal and factual and moral justice versus legal justice. So it is only a competent court of law that may deliver a verdict of legal guilt. Otherwise, the fact that people have seen you commit one act or the other doesn't justify an insinuation that one is a criminal. one remains a suspect until a competent court of law makes a proper ruling to that effect. So you see, that then means that during the trial process, the prosecution may not bring or lead evidence on previous convictions unless maybe the issue of previous convictions is an element of the current offense being tried. Otherwise, the state, so by the state we mean the prosecution, they should not lead any evidence to demonstrate that the accused has previously committed an offense, because then that would be prejudicial against them. And a trial magistrate or judge who has previously convicted the accused must recuse himself or herself from the case. So if you are appearing before the same magistrate who previously handled a case involving you, and you were eventually convicted before that magistrate or that judge, as a rule of procedure, in the next time you are brought before that court, that trial judge or magistrate must recuse herself or himself. In other words, must say, may you please take this matter before another presiding officer, because their previous knowledge about the previous conviction is actually sufficient to prejudice the presiding officer against the suspect or the accused. That's very, very important. And the state must prove guilt beyond reasonable doubt in respect of all the elements of the offense. Because you are presumed to be innocent, the standard of proof, therefore, is proof beyond reasonable doubt. It is the state that must prove beyond reasonable doubt that the accused has indeed committed the offense. So that is the standard in criminal procedure. And we are saying the principle of legality is enshrined in section 35(3)(I) of the Constitution, states that an accused person has a right not to be convicted for an act or omission that was not an offense under national or international law at the time that it was committed or omitted. So we are talking here about the principle of legality. As an example, if a certain act is not considered a crime according to the law, and then one person commits that act or omits to do whatever that is, and later on the legislature passes a law to say that that act is prohibited in law as an offense, the person who committed the offense before the passing or the adoption of the law cannot then be convicted for it. In other words, the legality principle says one cannot be convicted of any act which was not an offense at the time when it was committed. As you can see, the reason for this is self-evident. If one were to be convicted of an act that was not an offense, then it means people could observe you do certain things and then just sit down and craft a law and then arrest you and prosecute you and convict you ex post facto. So as a result, we are saying only conduct that is already deemed a crime at the time of its omission or commission must be punishable. Still looking at the presumption of innocence, you ask yourself the question, is it true that the presumption of innocence principle is the cornerstone of democracy in South Africa? And the answer is an affirmative yes. So the presumption of innocence is actually the principle of, is a cornerstone, is a principle which is the cornerstone of South Africa's constitutionalism. As we said earlier when we spoke about Section 8 and the apartheid, that Under apartheid, people could just be picked up and be tried and be convicted. Some were kept in detention for years because their innocence could not be presumed. But now the law says everyone is innocent. Whoever believes that somebody is not innocent must bring that person before court so that the court, a properly constituted and a competent court of law, may determine the guilt or the innocence of somebody. In fact, the guilt of somebody. The innocence is the starting point. We are innocent. So this lies at the center of the distinction between the crime control model and the due or legal process model, whereby we are saying the presumption of innocence and the right to remain silent are integral elements of constitutionalism. We have said that in the foregoing discussion. The rule of law and the legality principle are the center of constitutionalism. Remember about the rule of law and legality, we said one cannot be convicted of any conduct which was not an offense at the time when it was committed. And we are saying juridical guilt or legal guilt is more important, in fact, is important in constitutionalism. Not the factual or the moral guilt. The distinction here, as I said, people may have observed Mr. X committing a certain act or doing a certain thing. There's a tendency to go around and calling him a murderer or a rapist or a thief and so on. But as far as the presumption of innocence in law is concerned, that person is not a criminal but merely a suspect. That's why the police would say it is alleged that Mr. So-and-so entered the house and took away property that didn't belong to him. It's because the person is not a criminal, but the person remains a suspect. So it is not important just to secure a verdict of guilt at any cost and by any means whatsoever. The trial must comply with the rules of evidence and the rules of criminal procedure. In other words, right from the person, the time the report is made to the police, and then a warrant of arrest or a warrant of search is issued properly by a police officer who might be a magistrate, right through up to the trial person being arrested, brought to court, charges laid against them, their plea, and right up to the end, whether it results in a conviction or in an acquittal. All those processes must adhere to the principles of criminal procedure. The state bears the onus or the burden of proof to be discharged on the quantum of proof, guilt beyond reasonable doubt. So that's the quantum, that is the measure to say, in determining whether someone is a criminal or not, the standard of proof is proof beyond reasonable doubt. And then reverse honors provisions must comply with the limiting provisions of Section 36. What do we mean by reverse honors provisions? You see, in the past, there were so many statutes that would expect the accused to prove their innocence. But in terms of the current dispensation, everyone is presumed innocent. So those reverse honors provisions are not tolerable. But of course, Section 60.11 on bail does carry these reverse honors provisions. As an example, the burden of proof in bail applications is placed upon the accused to explain to the court why he or she should be released on bail, although facing this schedule 6 offenses or these serious offenses. So this shows an inclination towards crime control model in the interest of justice. So if you remember our discussion on crime control model as well as a due process model, we said that South Africa combines the crime control model and the due process model. You remember that part. Please revisit that video if you have forgotten about it. While we have highlighted that Section 35 elaborately protects the rights of detained, accused, arrested persons, you find that Section 36 is a limitation clause. It is the basis on which rights enshrined in the Bill of Rights can be limited lawfully. Well, the issue is that no rights are absolute. So the rights of the accused, the rights of everybody in a way, can be limited or curtailed. So, for instance, if we talk about the right to freedom of movement and liberty and security of the person, we find that such a right cannot be unlimited. For instance, a person who poses a danger to other people must be locked up in a cell away from the people. That's a way to secure other people who are facing the danger from that person. So we are saying all rights are subject to limitation, reasonable limitation. So Section 36 says the rights in the Bill of Rights may be limited only in terms of the law of general application to the extent that the limitation is reasonable and justifiable in an open and democratic society based on human dignity, equality, and freedom, taking into account all the relevant factors, including the nature of the right, the importance of the purpose of the limitation of the right, the nature of the extent of the limitation, the relationship between the limitation and the purpose, and the less restrictive means to achieve this purpose. So, except as provided in subsection 1 or in any other provision of the Constitution, rights may be limited in terms just of section 36. So what we are basically saying here is that while a person has a freedom of movement, a person has a freedom of security, of the person, as we have given an example, if that person's rights or if the enjoyment of their rights is actually affecting other people, it may be lawful to detain them. The same applies to a person who, on being lawfully arrested by the police, then unleashes violence on them and so on. They may then use a force to arrest that person, to overpower the person and bring them into account. So we are saying all rights are subject to limitation. The incarceration of people who have committed offenses, that is keeping them in prison, it is a limitation of their rights, but it follows due process. So it is, if it is in terms of a law of general application, in other words, a person may have violated a statute or may have committed a common law offense. That's the law of general application. So the law of general application simply means it is not an arbitrary act. In other words, it is a law that applies to everybody, not specifically to that individual or a group of individuals in that class. That's what we mean by law of general application. So, depending on the nature of the right and the importance of the limitation, it will always be practical and relevant sometimes and often to curtail and limit or restrict the rights of other people, certain people that is. Look now at the influence of the Constitution on criminal procedure. What has the adoption of the Constitution contributed? That is the 1996 Constitution. You see, it has adopted a Bill of Rights which then serves to restrict and moderate the power of the state in dealing with crime, forbidding torture. Remember, Section 12 forbids torture, if you remember that, while Section 35 has got all those beautiful and elaborate rights: the right to remain silent, the right not to testify in a court, the right to be presumed innocent, blah, 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 blah. So the limitation clause affirms that no rights are absolute, creates, that's very, very important. The Constitution has created an independent judiciary. You can check your section 165 of the Constitution. And then, you see, it has underscored the the importance of the rights of detained and accused persons. Whilst in the past, before 1993, that is before the adoption of the current constitutional dispensation, the police had excessive powers. We gave examples of Steve Biko being killed there while being interrogated by the police. There are a lot of other people who were killed in what they called interrogation, and the police were using excessive force, like the shooting and the killing of people there at Sharpeville. Remember the Sharpeville massacre of 21 March, is it 1960? So all those are very, very important, points to ponder regarding the need for tempering and moderating the powers of the police, because then they used to be very excessive. But now a police officer who opens fire and kills a suspect during during the process of arresting them, that police officer may himself face criminal prosecution and be convicted for it. So that's what the Constitution has done. Enforcing or affirming the right to remain silent, affirming the presumption of innocence. And the interesting part, as we said earlier on, the influence of criminal procedure on evidence. We said that if in the process of arresting an accused, a suspect, the police do not follow the due process, maybe they use unorthodox means of obtaining information such as torture and all forms of abuse, you find that such use of excessive force would actually be impugned, and the court may refuse to admit at all that evidence obtained in violation of the law. That is what Section 35 of the Constitution says. And then that is the influence of the Constitution on the gathering of evidence. So in the process of gathering evidence, the police must ensure that they follow the due process. In other words, they must obtain warrants, search and arrest warrants. They must inform the accused of the right to remain silent, so that everybody acts in line with the understanding of the expectations on them, that is the accused or the detained person. And then the Constitution has also affected, or rather led to the abolition of certain forms of punishment. If you have read the S versus Makwanyane case 1995, you would understand that from that time the death penalty was abolished. Even the Criminal Procedure Act itself had to be amended to remove those sections of the statute which authorized the courts to pass sentences of hanging and other forms of death sentence, capital punishment. So the adoption of the Constitution has actually affected so many things regarding criminal procedure, even to the point of leading to an amendment regarding the competent sentences that the courts may deliver, as the example of capital punishment that I just referred to. Yes, thank you very much for having been part of today's lecture. I hope it has answered so many of your questions. The lecture discussed the influence of the Constitution on South African criminal procedure. It outlined the main constitutional provisions relevant to criminal procedure. It explained the scope of sections 12, 21, and 35, as well as 36 of the Constitution, and illustrated the relationship between the Constitution and the presumption of innocence in criminal procedure, and it discussed the impact of the value of evidence obtained by the police action which contradicts the Constitution. The Constitution, yes. So we said that evidence obtained in violation of the Constitution is not admissible in a court of law. Right? This video is part of the criminal procedure series. Look for many other videos. We have a video on the introduction, basic introduction. We have a video on the distinction between criminal procedure and civil procedure. Then we have a video on the structure of the criminal courts, South Africa's criminal court system. And then we have a video on methods of securing the attendance of the accused in court. There are so many other ones. We've got one on, the impact of the Child Justice Act 75 of 2008 on the delivery of justice or criminal justice, particularly to do with the children below the age of 18. So look out for all those statutes, rather all those videos. I hope they bless you when you eventually find them. Remember to share the videos by when you find them on YouTube, share them with your friends. But if they are given to you privately, maybe when you have accessed them privately through a link, please do not share, because that's how I also get remunerated for the work that I do. Thank you very much for your time. God bless you.